Okay.
Well, good morning, and thank you for joining us for our breakfast briefing, Trustees Dealing with Uncertainty. Hope everyone's had a chance to get the coffee and the croissant. And I know that there are lots of people joining us remotely, and for some of whom it's very early and for some of whom it's very late. So thank you very much. I think it's fair to say that trustees are facing increased uncertainty, global, financial and political, in our current climate. And there's probably a limit to how much we as lawyers can assist with things like political uncertainty. But there are aspects of uncertainty that we can help with. And we're going to talk about three kinds today. So first of all, we've got Andreas Giannakopoulos, who's going to talk about factual uncertainty, Fenner Moeran, Casey, who's going to talk about legal uncertainty, and finally Sam Cathro, who's going to talk about uncertainty in trustee decision-making. And then we'll have some time for questions at the end. So we're going to start off with Andreas, who is going to talk about two ways of resolving factual uncertainty. We've got Benjamin orders and advertising.
Yeah, thank you very much. So I'll start with Benjamin orders, and then I'll talk about advertising, Section 27 of the Trustee Act. I suspect we all know what Benjamin orders are, but briefly, by way of reminder, Benjamin order is an order by which the court gives permission to a trustee to proceed to a distribution of the trust fund on a specified factual footing, when there is insufficient evidence to determine the fact one way or another. And that's typically and historically where a person had been missing for several years and the trustees proceed to apply to court to get permission to distribute on the basis that that person was dead or had predeceased. And I think there are three broad questions that I'd like to explore. First, what's the nature of the jurisdiction? Where does it come from? How far does it extend? And what are the effects of a Benjamin order? Then first, the nature of the jurisdiction. We think often of Benjamin orders as a sort of special type of orders, as developed by accretion around that seminal case from 1902 called Re Benjamin. It's not an inaccurate way of looking at it, but I think a more helpful way is that set up by Mr. Justice David Richards in a case called Re Emed Global UK Limited from 2013. And the facts are fairly complicated. I'm not going to go into them, but the main point he made at paragraph 26, if you want to look at it, that there's nothing special about Benjamin orders. They're just part of the inherent jurisdiction of the court to supervise and, if necessary, intervene in the administration of trusts. I think that's an important point. It's not just a question of taxonomy, because if you think of Benjamin orders as special, then there is a limit to which the courts can reason by analogy and apply them to new situations. Whereas if you look at them as just part of the type of orders that the court can make in its inherent jurisdiction, then it becomes much more legitimate for the courts to apply them to novel situations. That brings me to my second point about, the second question about the extensions of the jurisdiction over time. I think it's fair to say that Benjamin orders have moved their moorings in the case of missing beneficiaries quite a lot. And I'm going to give three examples of that. The first is where Benjamin orders have been used, not where there is uncertainty as to the whereabouts of one missing beneficiary, but generally where there are difficulties caused by the fact that there is a very large class of beneficiaries. And what the courts have said, generally in cases that cover discretionary trust, pensions trusts, and also in the case law, trusts of client money on insolvency. The courts have said that provided trustees have taken all reasonable steps to identify the relevant beneficiaries and have given them an opportunity to assert their claims, then the courts will, or at least are likely to give permission to trustees to proceed to a distribution on the basis that the beneficiaries that they have identified are the only beneficiaries. And that's a fairly significant extension of the jurisdiction, because it means moving from uncertainty as to one beneficiary to uncertainty as to the class as a whole, when generally it's a duty of the trustees to survey the field and identify the class. But it's a pragmatic solution, and the aim is to ensure that the trust fund is not held up simply because the class is largely and loosely defined, which may originally have been just for reasons of confidentiality or flexibility. That's quite a practically significant extension of Benjamin orders. The second case is where there is uncertainty as to whether a beneficiary, usually a female beneficiary, but not necessarily, is past childbearing age. And the reason why that's relevant is because if the beneficiary is past childbearing age, then it means that she or he may have no further issue. In that respect, the class may have closed. Something that's important for the beneficiaries to know, obviously. And there are two cases from 1960s where the courts have considered applications by trustees to distribute the trust fund on the basis that a woman would have no further beneficiaries, would have no further children. The first is Re Westminster Bank Limited Declaration of Trust, which is a decision of Mr. Justice Wilberforce. And in that case, the court permitted trustees to administer a trust fund on the basis that a woman in her 50s would have no further children. And the court looked at the medical history, her age, the matrimonial history, and the medical evidence. In a separate case, which is a bit more baroque perhaps, the trustees applied to court for permission to distribute on the basis that a 78-year-old woman would have no further children. The court said, well, we shouldn't come to court to cover an impossible contingency. That's going a bit too far.
Sorry to interrupt. What does that mean now in terms of kind of modern medical, medical advances? So we've got increased prevalence of people doing IVF, lots of couples trying to conceive using and freezing their embryos. So doesn't it mean it might be quite difficult to get to the point where you can say a person is no longer going to have any further issue?
Yes, I think that's one of the key questions as to whether those orders remain appropriate nowadays. You look at IVF, you look at egg donors, surrogacy. There are many ways for people to have children past childbearing age. And therefore, I suspect, it's my sense that the court would be very cautious about giving permission in those circumstances nowadays, unless there's very compelling evidence that somebody will have no further children. For example, if somebody is paralyzed, or if somebody has made it clear that they have no intention of having further children. And
so I think I agree with you. I think there's likely to be a shift by the courts, and I'll flag up 2 points. There was a shift in the 1990s when you were making court applications for variation of trusts as to whether or not somebody might get married, and therefore their spouse might be brought into a class of beneficiaries, whether they might get married in their 80s. And you could make an application in the 80s under the Variation of Trust Act, and the court would just go, yeah, they're in their 80s. They're never going to get married now. They've got their last husband died 20 years ago. In the late 90s, early 2000s, everybody went, no. Everybody gets really quite frisky in their 80s. So we're not going to assume that. And besides the awkward questions from your clients going, but mum, don't ask. And so there was a shift culturally and socially in the court's approach to that sort of application. I think that's likely, if it's not already happening, and I think it is, that's likely now. The second thing was there was a Supreme Court in the United States on a Roe versus Wade decision where Ruth Bader Ginsburg, a great RBG, pointed out that the decision in Roe versus Wade was, if you gave birth to a child before your first trimester was over, that child could not survive. And this was part of the rationale for Roe versus Wade. And she said, yeah, it still works, but at some point, given medical advances, that argument will stop working. So and I think that's a good flag for, at some point, the physical arguments stop working practically. And I think that's likely to happen with the English courts.
Yeah. And I suppose in a similar vein, I was reading an article recently in The Guardian, I don't always read, but I read it for the purpose of this talk. If you've heard of Pavel Durov, who's the founder of Telegram, that's a Russian messaging app, and what he did is a bit like Elon Musk. He was concerned about repopulating the West, and well, Russia and the West in that case, but and he made a number of sperm donations to sperm banks with a hope that that would assist his project. He has, I think, 4 other children. And his plan is announced that when he dies, he will leave his fortune of $14 billion, I think, to his over 100 offspring, I think, for now, from sperm donations. And I think you can conceptualize it. It's a real nightmare for trustees because,
putting it mildly,
yeah, I mean, those children will be in many different jurisdictions, which may have very different laws on anonymity with regard to sperm banks. You've got to find them. You've got to also think about the fact that frozen spermatozoa might be used well after Mr. Durov is past childbearing age or dead. And the children themselves may not know that they are the offspring of that man. So advertisement, for example, might not work. And so I think that's one of those cases about reproduction where Benjamin Laws could still be people trustees would want to get permission to distribute on the basis that the children they have identified, the only children he's got. So that's looking into the future. After this heavily reproductive interval, I'll talk about the effects of Benjamin orders. And it's not too difficult. A trustee has immunity from claims as a result of a Benjamin order. The order doesn't determine rights, doesn't extinguish rights, so the beneficiaries can still trace and follow the property into the hands of recipients. Well, I don't know, maybe it's an imperfect analogy, but I think I felt there was something of an analogy with limitation where it bars a claim but doesn't extinguish rights generally. And the reason why I think that's important also for procedure is because since it rules on the particular immunity between trustee and the beneficiary, you want the prejudiced beneficiary to be bound by the order. And the way you do that is usually by a representation order under Rule 19.9 of the CPR. There's something of a logical contradiction because you're saying that that beneficiary doesn't exist, but at the same time you're trying to bind that person. But I think it's a pragmatic solution to otherwise intractable problem. It's also important to seek to bind the people who will receive the trust property as a result of the distribution, so they don't turn around and try to sue a trustee if they are forced to repay the property to the beneficiary who appears after the order has been made. And well, as Sam will explain, following Denaxe, the preferred approach is to join those people either by representation order or individually, although technically you can still issue a claim form without naming a defendant. That covers what I have to say about Benjamin orders, and I'll move on to advertising, which is probably the first step you should take if you can. Benjamin orders are expensive, and if possible, advertising will do 2 things. It will support you in the Benjamin order application. If you try to advertise for claims and try to find beneficiaries, then that will help persuade the court that you should be allowed to proceed to distribution. But even itself, advertising can be a source of protection under Section 27 of the Trustee Act 1925. I think most of us are familiar with that section being used by PRs to try to identify creditors or beneficiaries, but it's also available to trustees where there is uncertainty as to a particular beneficiary, as to whether a particular beneficiary exists or is still alive. I'm not going to read out the section, and it's on the slides, but it's fairly simple. Essentially, either trustees or PRs give notice in a newspaper that they intend to make a distribution after a specified date, and they require interested parties to make claims. Then they may distribute at the end of that period among the interested parties who have given notice of their claims to the trustees. Practically, the way it works is that you need to ensure that the terms of the notice are sufficiently precise and identify the class. So usually it's fine to mirror the terms of the trust, in particular the terms that identify the beneficial class. There is a tricky question about which newspaper you use. The section refers to the London Gazette. I suspect not many people read that, apart from company lawyers, maybe. It's also good to use a national newspaper if you have the money, or if land is involved, a local newspaper will do. I suspect that in future we may slowly move towards a position where advertising online might be more effective, and is something a trustee would consider and that the court would accept. That just a final word on the effect of advertisement is the same as for Benjamin orders. It gives immunity from claims by the beneficiaries who haven't given notice of their interest in trust property. It doesn't extinguish rights and doesn't determine rights, so the beneficiaries can still follow and trace the trust property unless there is some offence. With this concludes my remarks.
Thank you.
I mean, before we get into that, Sam and I and Andreas were discussing the issue of the practicalities of advertisement. And again, this is something that's been developing through the courts. When I started practicing in '97, there was really quite fixed procedures or fixed practice as to how you would advertise claims. You'd advertise in the Gazette, and then there was like a flowchart of you would work out where the local papers were. If you were in Bolton, it was the advertiser, but you might also do the Times if it was a good estate, if it was a valuable person. These days, and that's your statutory one. And then you've got the advertisement for the purpose of identifying missing beneficiary under Reed Benjamin. And then you've got the practicalities of if somebody was last seen in Sydney, Australia, do you advertise in Sydney, Australia? Do you go to the whole of Australia? That sort of stuff. Now, it's been a while since I've done one of these, but I wouldn't be surprised if quite soon they start doing online advertisements, either for statutory purpose or for practical, can you find somebody purpose? And Sam has some comments, I think, about sort of online.
Because when we were talking about this yesterday, Fenner was saying, well, maybe this will just go away entirely and people will stop advertising in newspapers because no one really reads them anymore. But actually, it seems a bit odd in a situation where it's really easy to find people online, and the methods of targeting online advertising are getting more and more sophisticated so that you can find a particular person with a particular demographic who's interested in a particular thing. And so surely there'll be a time where the courts permit advertising to be made through those more sophisticated methods online.
Yeah, so, you've got this, when you're doing electronic disclosure, you've got your flowchart of words and how you do that sort of stuff. I can completely see a time in 2 or 3 or 5 years where they go, right, you should be advertising for males between the ages of 75 and 85 who are British nationals or originally British nationals who moved to Australia in the period between 1970 and 1980, who originally lived in the area of Sydney. Bing. That will cost you, I know, $250 on Google. And the next thing you know, Uncle Bobby has popped up. I mean, hypothetically.
For example. Thank you very much. Thank you, Andrea. So that's all we've got to say about factual uncertainty. Fenner's now going to talk to us about legal uncertainty, in particular, one way of resolving legal uncertainty in particular.
Right. What's a trustee or a personal representative going to do when they face a situation of legal uncertainty? Now, you ask a barrister and the automatic answer is, go to court, get a ruling, get a decision, because you'll pay me lots of money on the way. Aside from the financial implications, or indeed as part of the financial implications, that's great, but it does cost a lot of money. It also takes an enormous amount of time. Even for a simple point, a one-day hearing, you are looking at a minimum of 6 months from start of proceedings to trial, probably more like 12, 15 months. There has to be a better way, at least for the smaller, the simpler situations. And I think that there is. It's provided by the Administration of Justice Act 1985, Section 48. Now, for English trust lawyers and estate lawyers, this is one of those things that everybody's kind of heard of, kind of familiar with, but almost nobody has actually done, which I think is a pity, because it's far more useful, in my opinion, than people give it credit for. Now, I'm emphasizing this is English lawyers or English and Welsh lawyers, because I'm not aware of any equivalent to this statute anywhere else in the world. Now, I could be wrong, and if I am, if anybody has one in their jurisdiction, please do let me know, because I'm fascinated by this. But I don't think there's anything comparable anywhere else. There's not even, as far as I can tell, a Scottish version of the statute. So, AJA 1905, section 48. Let's start with the wording of the statute. It's very simple. It's one section. Sub 1, where any question of construction has arisen out of the terms of a will or a trust, and B, an opinion in writing given by a person who has a 10-year High Court qualification has been obtained on that question by the PR or the trustees. Then the High Court may, on the application of the PR or trustees, and without hearing argument, make an order authorising those persons to take such steps in reliance on the said opinion as is specified in the order. And then sub 2, the High Court shall not make an order under sub 1 if it appears the court that a dispute exists which would make it inappropriate for the court to make the order without hearing argument. So section 48, 5 questions come out of that section. First off, whose opinion can you rely on? Now, originally, this section required an opinion by a barrister, but it's now anybody with a High Court advocacy qualification of 10 years. So this can be done on the basis of a solicitor's opinion. I'm not trying to stop work coming to the bar, but in the right case, with the right situation where you've really delved into the question and you've got the answer, this could be a really cheap and quick solution for your client. So I think that's worth holding in your back pocket. 2 practical points. First of all, make sure you've got evidence of the 10-year qualification. There's a couple of different cases that flag up that certain evidence didn't actually cover this. You can usually cover this by, you can usually correct it by putting in further evidence, but the courts are pretty particular about this. Even if you think you're fabulously well known in the Chancery Division, it turns out that Fenner Moeran, his year of call is not well known by the judges. Put in the evidence. Second point, it's got to be an opinion produced for the trustees or the PRs. You can't go on the basis of an opinion produced for one of the beneficiaries that they then gave to the trustees or PRs. I mean, you can see the obvious problems about conflicts of duties and interests. So let's start with your opinion. Next question, what should that opinion cover? Well, I mean, somewhat obviously, it should cover matters of construction. But I would highlight that matters of construction includes questions which are covered by correction by construction. And that's where you have a clear and obvious mistake and a clear and obvious correction to it. So where, for example, a will says, oh, everything should be distributed by 1st of January 1928, it's obvious that it should say 2028. That's a correction by construction type situation. Why am I emphasizing this? Because in practice, quite a lot of these really stupid little problems, which the answer is obvious, but my God, it would be expensive to go to court about, arise out of that sort of poor typographical error type situation. You could correct these things, not by construction, but by rectification. But here's the problem. Section 48 does not allow for rectification, or at least that's the state of the authorities as they currently stand. It says, I mean, the statute just talks about construction, rectification obviously isn't construction. And the case of Greenwald and Pike, which was Mr. Justice Briggs, as he then was, he just basically said, statute says construction, not rectification, there you go. I do think, though, although Greenwald and Pike is obvious on the interpretation of the statute, I do think it gets complicated today because of last year's Supreme Court decision in the Tyne and Weir case, or to give it its full name, National Union of Rail, Maritime and Transport Workers against Tyne and Weir Passenger Transport Executive Trading Nexus. So if you haven't heard about it, it's a doozer. And you may not have heard about it because if you're a trust and estate lawyer, this is about employment rights. And it was all about collective bargaining and collective agreements, which I do not need to delve into for our purposes. But what it dealt with was rectification. It really turned on the terms of a legally non-binding collective agreement, which the employers in that particular case said did not record the intentions of the parties. And the question was whether the employment tribunal could take into account what the collective agreement should have said if it had been rectified. And the Supreme Court came to a decision on 2 points and a sort of corollary. The first point was, you can rectify non-legally binding agreements, which is interesting. And I suspect for all of us online or in the room today is quite useful for things like, I don't know, letters of wishes. You can rectify a non-legally binding agreement. Great stuff. Second point, more substantial for today, employment tribunals do not have a power of rectification. They're a purely statutory body, and if you read through the statute, it just doesn't give them the power of rectification. Maybe an omission, there you go. But the Supreme Court held that despite this, they could in law treat this document as if it had been rectified without making a formal order on the basis of equity treats as done that which ought to be done. I mean, I personally think that's a bit of a stretch of the maxim, but it's the Supreme Court, so who am I to say? So rectification is available even if it hasn't been done sort of by the back door. There's a sting in the tail though. The Supreme Court flagged up or highlighted that you shouldn't be treating documents as if they've been rectified, where other people's rights would be affected by this quasi-rectification, unless those people have had an opportunity to make submissions. Because otherwise, I mean, it's pretty obvious it's a breach of natural justice, breach of procedural justice. So, taking this all as one, you don't have to rectify to treat as if it's been rectified by a court, but you should be making sure that parties are represented if you're going to be truly rectifying it. Now, I'll come back to the parties point, but subject to that parties point, it looks to me, on the basis of the Tyne and Weir case, like Section 48 applications could basically assume that rectification has taken place. No reason not to. So, assuming that you can kind of take the rectification, put that to one side. Third question, when can you get a Section 48 direction? Or to put it another way, what's the test for a Section 48 direction? Oddly enough, statute doesn't say. All it says is when you can't get a Section 48, but which is when it appears to the court that a dispute exists, which will make it inappropriate to make the order without hearing argument. Now, actually, one point importantly comes out of that, which is clearly you don't need no dispute. Clearly, you can have a dispute, just one that's not where it's inappropriate to have argument, etc., or a decision without argument. And also, as a matter of practicality, if you've got literally no dispute, why would you be bothering to go to court in most situations? I say that, but here are my thoughts on the type of situations or type of disputes that Section 48 could cover. And the first one is where there is no dispute. And the reason for that is, even where you've got no dispute, you regularly have moaning beneficiaries. And I think probably everybody here or online has had this situation. You've got one of the most common problems I see in administration of estates, administration of trusts, is where you've got that one recalcitrant beneficiary, usually a discretionary beneficiary or contingent beneficiary, who goes, no, I disagree with everything you're doing. Black is white, green is blue, I don't care what you do. We'll never agree to it. And I'll warn you, if you take action, I will sue you, or at least I will reserve my right to sue you. And the trustees and the PRs are sitting going, God, how do we deal with this? It results in slowing down of administration. It results in massive slowing down of winding up of trusts and estates. And if it doesn't slow it down, it costs more because you're buying insurance policy to cover this, you're making retentions, you're getting indemnities and so on and so forth. And even if you've done all of those things, you might have post-administration years of litigation where some annoying person sits there and complains about actions 5 years ago. If it's a construction issue they're complaining about, Section 48 can give you a real-world answer to this. It's not perfect. Let me emphasize, it's never going to be an ideal solution because they can still complain about it, but it's a massively simplifying situation. Every time they complain, you just wave the order in their face. So that's your answer. First type of dispute, there is no dispute, but it's bloody useful. Second type of dispute, very, very minor disputes, very, very minor doubts. So if your barrister is saying, oh, I have 95% chance of success on this interpretation, and they're only saying the 5% because you never get a barrister saying 100% or no sensible barrister, yeah, fine. Section 48 is pretty obvious. Third type of dispute, and this is the important one, economically unreasonable disputes. So where the costs of going to a full trial are going to be massively disproportionate to either A, the risk that you've identified, or B, the benefit that might be obtained by the person who's done down by this. So two examples. Say you've got a 90% chance of being correct. It's not, there is no argument and I'm just being cautious. It's, there's a really crap argument. It's not a real prospect of success. It's not a summary. You would win on a summary judgment application and you're accounting for mad judgeitism. But the costs of that mad judgeitis and that summary judgment would be £500,000 because you've got to get a representative beneficiary and something like that. This is not a dispute, or I think this is not a dispute that makes it inappropriate to give you Section 48 relief. What happens if your barrister or your solicitor says, oh, it's a 75% chance of success. It's a bloody good, clear argument, but there are a couple of caveats and it's not quite summary judgmentable. This isn't no prospect of success, but say the estate's worth £1 million, say the argument is only worth £50,000 to the potential residuary beneficiary, but the costs of arguing it are going to be £500,000. I mean, not only is it barking mad to take that application, it is wildly unfair on all the other beneficiaries, on all the other residuary beneficiaries, to spend that half of the estate on something that's worth 10% of that cost. So I personally think that sort of economic unfairness or economic unreasonableness is where Section 48 really bites. There are no cases that say this, but there is a passage in Lewin on trust that has been cited with approval in a case. So passage on Lewin on trust says there may be a dispute in which one of two competing constructions is obviously wrong, or the matter in issue may be too insubstantial to justify more than a summary decision. And that was quoted, I think, with approval in a case called Clark-Sullivan against Clark-Sullivan. So that's the third type of unreasonableness. I think very valuable to have in your pocket. Fourth type, either the person who might be done down is agreeing to this, or nobody might be done down by in reality. The case is called Reed Duffy, where there was whether or not a bequest was void void because it was a non-charitable purpose, basically saying, oh, we'll give money to the local people. And the judge said, not only is this void for non-charitable purpose, but also the local authority had been notified and said, I don't care. And the judge held, because the local authority has said, yeah, I don't care, there was no obvious person who might have an interest in opposing it. There are lots of other people who have an interest in opposing it. There's all the local people, there's the Attorney General. So I think what he was talking about there was a practical interest in opposing it. If that's right, then you can kind of ignore the ultimate terribly remote beneficiary like the Red Cross in a Red Cross trust, following on possibly from how the Guernsey and Jersey jurisdictions have been dealing with Red Cross trusts over the past couple of years. Maybe a practical point there. So you've got your, when are you going to do it? Procedure, it's really simple. It's on paper, chuck it in, see how it goes. The really important thing on procedure is you do not need a defendant. Massively helpful. In fact, the presumption is you do not have a defendant unless the court says you really ought to do. If you don't have defendants, though, is that quasi-rectification point that I was flagging up a few minutes ago, is that available? Because would this not reduce their rights, their interests without the chance of submissions? Isn't this a natural justice, procedural justice situation? Hold that thought, because one major qualification or justification for why you don't need a defendant is my fifth point. What do you actually get? You don't get a binding determination. Rather like a re-Benjamin order, you get a direction that the trustees or PRs can do X, Y, and Z, and they can't be sued if they do X, Y, and Z because they've got a direction to do so. But it doesn't stop the hard done by beneficiaries from complaining or suing or bringing their own construction summons, or if the money has already been paid out, suing the recipients on a re-Diplock type claim so they can basically trace into the proceeds. Again, very much like a re-Benjamin order in those situations. I mean, that said, let me emphasize, no Section 48 order that I'm aware of has required advertisement or insurance like a re-Benjamin order quite often does. But that non-binding determination is why this is not a re-Denaxe situation that Sam's going to be coming to in a few minutes, where you worry about binding all the relevant parties. And it's also why I think it might be possible to get a Section 48 decision on the basis of quasi-rectification, on the basis of the court saying, yeah, it's bloody obvious it's going to be rectified. Because since the hard done by beneficiaries aren't bound, they aren't excluded from their rights of proper hearing, it's not a breach of natural justice, it's not a breach of procedural justice. So I think Section 48, very useful, slightly more flexible than people think, slightly more useful than people think. Okay.
I've got one comment and one question. The question first is, are you saying in those type of cases where you've got two alternative constructions which are both reasonably open, you get an opinion that says both reasonably open, the judge could go either way, but in my view, the correct interpretation is X.
I think when you've got two reasonable interpretations, you're unlikely to be a section 48, because the court at that point is going to say you should be having an argument in these situations. And I'm not going to just go with it's really expensive, so I'm going to give it to A rather than B because it's a 51-49. I think you have to have a pretty solid argument that it's A rather than B. And you can say B does have arguments, but it's too expensive to argue about. So we're just going to do summary determination. But if it's both are reasonable arguments, problematic. I think unlikely.
Okay. And the comment that I was thinking of while you were talking is you haven't found any equivalent to Section 48 in any offshore jurisdiction that you looked at. But do you think that there's a possibility, and in fact, I'm thinking of cases that I have done where in an offshore jurisdiction, you go under the general blessing power.
Absolutely.
And
yeah, massively. I think that one of the reasons you don't have Section 48 or you don't need Section 48 in offshore jurisdictions is because their blessing jurisdiction is wider. And I think also procedurally, if you turn up in Guernsey or Jersey or Cayman or BVI or Bahamas, you start off with, do we need anybody else here for a blessing? Do we need anybody else here for a rebedo application, which is it's a specific subset of blessing application. And in the really obvious cases, the judge will just go, we don't need a defendant for the bedo, therefore we can move on. So it massively simplifies, it keeps the cost down in the blindingly obvious situation. That is slightly changing. So Guernsey and Jersey over the past 5-7 years have moved towards, even on a pretty obvious one, at least notify the beneficiaries more and more of that type of application. I think as that increases costs, people might start thinking about the question of some sort of Section 48 type relief. But at the moment, I think you can get the same equivalent relief at the same sort of cost or sort of procedural complexity, because they are more flexible with the requirements as to parties when it's a blindingly obvious case for trustees. And these jurisdictions are much more used to, or much more user-friendly for technical applications by trustees.
Yeah, and I'm also thinking of cases. I mean, I've never been able to get anything done on the papers here. But offshore, I've had quite a lot of similar types of blessing applications being done on the papers. And what you have is equivalent really to Section 48, where it's a construction issue, because in your evidence, you'll put in the opinion that says this is a really obvious construction issue and the answer is X. That's the evidence that goes in and you ask for the blessing. And you can get it on paper.
Yeah, I entirely agree. I suspect the interesting point will be when you say to the court, the reason I'm doing this on the papers is economic unreasonableness. And at that point, I think you might see a different approach by the courts going, I get it's not that they don't recognize or acknowledge the economic unreasonableness. I just think they are probably sitting there going, the reason we don't need anybody here is the lack of argument rather than the cost of argument. I'm not sure about that. I think this is something that the local lawyers will have a better feel for. I'd be fascinated to hear anybody's comments about it.
Thank you. Okay, we're going to move on now to Sam, who's going to talk to us about uncertainty in trustee decision-making in a post-Denaxe world. We're still talking about Denaxe, aren't we?
2 years on. Yeah, so often trustees will be faced with a difficult or momentous decision with potentially significant consequences for the trust or for the beneficiaries. And the trustees might want to take a decision and then have that decision blessed by the court. And the main reason why they want to do that, as you'll know, is that they want to be immune for being sued by beneficiaries in the future. There are several familiar issues that arise in this context. For example, whether and when the trustee can surrender their discretion to the court, whether non-binding guidance might be available. But I'm going to be focusing on the question about how to bind the right people. And I'll briefly discuss Denaxe and remind us what that case stood for, and then mention a more recent case study that I was involved in where this came up. So Denaxe itself was a decision of the Court of Appeal in 2023. It was a case involving the sale of a football club by receivers. So it's not obviously a trustee case, and that might go some way to explaining why the reasoning is not particularly usual or familiar to trust lawyers. However, the court did proceed on the basis that trust principles applied in that scenario, essentially on the slightly uncertain footing that no one thought that anything else should happen. So the receivers brought an application the court seeking approval of their proposed sale of the football club, and the application was granted. One of the interested parties later commenced pursuit of challenging that decision. And the court held that that interested party should have raised its arguments earlier on. There was a party that declined to engage at the original blessing stage, and so it was barred from raising its objections later by the application of the rule in Henderson and Henderson. And that's fairly straightforward. That seems to make sense. Nothing much to see here from a sort of ordinary principles decision. But where the court went a little bit off beam, perhaps, compared to what trust lawyers would have expected, is that the court said that this Henderson and Henderson argument explains the blessing jurisdiction and the way in which blessings bind parties. And the court suggested that perhaps trustees who bring blessing applications wouldn't have the protection of the immunity unless all of the parties who they wanted to bind were actually joined to the proceedings. And there's a few reasons why trust practitioners have been unsure about this since the decision came out. The first one is that it's just inconsistent with the previously received wisdom, which was that you didn't necessarily need to bind everyone that you wanted, or you didn't need to join everyone you wanted to be bound. The sort of principled reasons are that it actually is contrary to some of the principles in the CPR, which the court didn't seem to have engaged with. So, for example, CPR 19.10 provides that a claim brought by trustees can be, or is binding, even if not all the beneficiaries are joined. And that seems to be quite inconsistent, perhaps, with what the court ruled in Denaxe. And similarly, there are provisions in CPR 64 and Practice Direction 64B, which suggest that the trustees don't necessarily need to bind or join all of the parties, and it might be appropriate only to join some of them where the other beneficiaries weren't joined, where their views are already being advocated by people who are party. So all of those previous sort of principles run perhaps slightly contrary to the Denaxe decision. So far, so familiar. But what I'd like to move on to talk about now is a recent case study about how this decision has been treated in practice. And this was a case that I was involved in late last year. It's called White and Zavos. And as far as I know, it's the only case in England where Denaxe has been considered and applied in the trust context. I appeared on behalf of the minors and unborns and the unascertained beneficiaries, led by Jonathan Hilliard KC in Chambers. And in fact, the trustees were represented by Michael Finnis KC and Jenny Holmes, also from Wilberforce. And interestingly, shortly before the hearing, it became known to us, in fact, I think it was just 1 or 2 days before, that the judge who was going to be hearing the decision was Mr. Justice Fancourt. And Mr. Justice Fancourt was the judge who'd given the first instance decision in Denaxe and applied the traditional trust principles, which everyone thought would apply in the Court of Appeal. And as we know, the Court of Appeal departed from that reasoning. So there was an interesting mood in the room at that point, because the sort of flavour, perhaps, of the submissions and probably the vibe between counsel was that those there had some concerns about the way the Court of Appeal had approached Denaxe, but they weren't necessarily going to invite Mr. Justice Fancourt to overturn the Court of Appeal who departed from his own reasoning. So there was a certain amount of circumspection involved in the submissions. So turning now to the facts of that case briefly, it was a case involving a large landed estate in London, and the decision in broad outline was a decision to incorporate that estate. So the estate assets, all of the properties in London were held in trust, and the trustees had decided that they wanted to incorporate the estate and move all of those assets into a company. And it was a very complicated decision. It involved lots of stages of decision making. There were reams and reams of expert reports at various stages of the proceedings. The paperwork was enormous, and it was a very expensive exercise. And the trustees decided in that situation not to join all of the beneficiaries of the trust. And the particular beneficiaries that they didn't join only had very limited beneficial interests. In many cases, they were contingent interests, or they were a 12th, a 12th, a 12th of a fund, which may or may not fall in. The trustees took the view that those beneficiaries' interests were aligned with the interests of other beneficiaries who were in fact joined to those proceedings. They also took the view that it would have been very expensive to pay for all of these more minor beneficiaries to read in and to instruct experts and lawyers of their own, and that if the fund was ultimately bearing that cost, it might have been disproportionate. And also, our instructing solicitors had been appointed basically to argue the counterfactual and to test the trustees' evidence. So Some of those themes are come up in other people's talks already. This situation where you might not necessarily want to join someone because it's going to be expensive or impractical. And the question is whether that is okay, whether you can continue to do that in a post-Denaxe world. And unhelpfully, you might have hoped for a silver bullet, but the actual outcome in that case was possibly somewhat equivocal at the end of the day. And so the judgment records that in light of Denaxe, there may be more limited protection for trustees if they don't join all of the relevant beneficiaries. And it also records that the trustee accepted that the beneficiaries it had not joined might not be bound, but they decided that they were willing to run the risk. And so as a sort of conclusion, that's a bit of a fudge perhaps. It sort of says, well, maybe they will have less protection, but it didn't say they wouldn't be protected. The position wasn't really clear either way. And on the facts of that case, it probably wasn't all that problematic, because as I've explained, the beneficiaries in question only had very minor interests. And so even if they had complained about it at some point in future, they probably wouldn't have suffered any loss. But it might be more problematic in other situations. You can quite easily think of scenarios, again, similar to ones that Fenner and others have raised earlier, where you might have that sort of recalcitrant or really troublesome beneficiary who always kicks up a fuss. And if they have a bit of skin in the game, if they stand to suffer quite a lot from the decision, even if they don't have a very good argument, you might still be faced with this more difficult decision about whether to join them or not. So the sort of takeaway is we're not really sure where we are years on, but you've got one more case to cite in your skeleton argument or in your submissions. The one point that I'd like to conclude on is to talk about the offshore jurisdictions and the impact that that Denaxe might have over there. And in fact, there are a number of jurisdictions where Denaxe probably won't have any appreciable impact. In particular, in the Isle of Man and in Cayman Islands, both of those jurisdictions have statutes pursuant to which trustees can bring blessing applications and where trustees are more clearly protected. And both of those statutes, so there's the Trustee Act 1961 in the Isle of Man and the Trust Act 2021 revision in Cayman, both contain terms which effectively say that if the trustee brings proceedings, they shall be indemnified, and the hearing need only be attended by such beneficiaries as the court thinks expedient. So it probably goes one step further than the provisions of the CPR in saying that the court can join whoever it considers appropriate, and the trustees will be indemnified as a result. The CPR provisions don't go quite that far. And I'm told, as an aside, that both of those provisions are based on a very old and now repealed act from England and Wales in the 19th century. Robert Ham told me this, but I wasn't able to track down the particular statute that he was referring to. He also says that it was repealed because everyone believed that that was the position anyway at common law. And look where we are now. Maybe it would have been better if we were still governed by the impossible to find 19th century act.
I'm personally suspicious about that repeal argument. I think that's Robert being optimistic.
I think it is interesting though, because having done blessings, in particular using the Isle of Man statute, I think 10 years ago, people, the kind of view was, well, that statute didn't add anything for common law. You're really in the same position that you would have been in England and Wales. And now I think it's becoming clearer that there is still this uncertainty after Denaxe. And if you're in a jurisdiction where the statute provides that the trustees will not have any liability if they get a blessing under that section, you're in a much stronger position. So I think that's really interesting that there's been that departure. We're heading towards a collision, aren't we? There's got to be a case that's going to come up where you won't be able to kind of skirt around Denaxe. Someone's going to have to deal with it.
You're right. I mean, there's 2 points I'd say to that. The first is that there is quite a lot of scope for skirting around it, as in our case. You can sort of decide that it's going to be all too expensive to join them and hope for the best. Or if it's sufficiently concerning to you, then you can just suck it up and join everyone. And again, that they should be bound. But you're right, there's likely to be a case at some point where you're in a position where you don't want to join the beneficiaries for very good reasons, but you're concerned enough that they're not going to be bound that it's going to present a real problem. The second point is that because Denaxe is unhelpfully a Court of Appeal decision and permission to appeal to the Supreme Court was refused, it's probably not, it's going to be a while until we have a case that goes all the way up to the Court of Appeal and perhaps further to really put this one to bed. The last point that I'd note, sort of tying up the offshore jurisdictions position, is that at least in Jersey and Guernsey, I think the position is probably slightly better than it is here. I haven't found any cases applying Denaxe in Jersey and Guernsey, but please correct me if I'm wrong about that. But as we've already mentioned, in both of those jurisdictions, the usual practice is to have a convening hearing at the beginning where the court decides which party should be joined. And so one would have thought, at least in that situation, you'd have a stronger argument that the court, having decided who should be parties, that the decision will grant greater indemnity to the trustee than it might otherwise. Although query whether that's much further than the CPR, which says that those joined should just be whoever the court considers appropriate. I think there is a decision, at least in Guernsey, called Can Argo, where the court essentially applied or held that the blessing authorities in the restructuring and insolvency context also apply in the trust context and vice versa, which is a similar argument to what was made in Denaxe. So there could be a scope to argue that Denaxe should apply by analogy in Guernsey for that reason, but that's an open question.
I have one question about Wyde and Zavos, which is, why did you not just get a representation order? If your client had kind of been appointed to take the argument, could you have just got a representation order that would have covered this?
Yeah, I'm not sure about that. There must have been a good reason why.
There must have been a good reason.
Why we were, because I suppose we were appointed on behalf of the unascertained and minor beneficiaries.
Oh, I see. So you already were a represented body. You just
Yeah,
didn't cover every possible representation.
We weren't representing the other beneficiaries who could have represented.
You would have
them,
needed
but
another rep then because they had slightly different. Okay,
Yeah,
I get that.
yeah,
Okay.
yeah.
That representation party point, in my experience, the offshore jurisdictions tend to use representation orders less. They tend to take more of the approach that will just give a direction on the initial hearing that we don't need the other beneficiaries and so on. I think the English courts are more used to using representation orders because they come up in all sorts of cases much more regularly than the offshore jurisdictions do. So I suspect if you've got a problem in England and you're really genuinely worried about it, get a representation order, it will probably solve your problems. It will cost a bit, but it will probably solve it.
Thank you. That's all that we've got for you. So if there are any questions, you're very welcome to ask them now or to come up and ask us afterwards. If there's any questions online, you're very welcome to email any of us. But thank you very much for joining us.